high-profile ritual abuse case dismissed. A rare rebuke of the court from the Utah County Sheriff's Office.
And now multiple attorneys are calling out what they believe are false claims by law enforcement. KSL investigator Daniela Rivera has been digging into the fallout of the case against former Utah therapist David Hamblin.
It's rare to see a law enforcement agency release a statement scolding the courts for dismissing a case. It's even more unusual to then have attorneys calling out that agency for releasing false claims about the case to the public.
They're misrepresenting the facts.
Provo attorney Caleb Prue has been closely following the case against former therapist David Hamblin. In 2022, now former Utah County Attorney David Levitt and Utah County Sheriff Mike Smith publicly traded barbs in dueling press conferences.
First off, this is not a politically motivated investigation.
That investigation into what the sheriff's office calls ritualistic child sexual abuse. Driving the controversy, a 151-page victim statement naming Levitt, his wife, and dozens of others.
Alleging that we were guilty of cannibalizing young children.
Prosecutors later filed sexual abuse charges against Hamblin, resurrecting a case that had been dismissed in 2014 for evidentiary reasons. But on February 19th, a special prosecutor filed a motion to dismiss the case, citing evidentiary concerns and discovery problems. Last month, a 4th district judge agreed, issuing a written ruling, again dismissing the case, but this time with prejudice, meaning it can never be refiled. The court finding this case is rife with problems with evidence and discovery issues. The Utah County Sheriff's Office then issued a scathing rebuke, calling the outcome of the case abhorrent and making several claims attorneys tell KSL are flat out false. For example, claiming the prosecution and defense met to discuss the evidence and, quote, the defense attorney acknowledged that they had received everything. But defense attorney Leah Aston told KSL investigators that is false, writing, defense counsel still does not have all of the discovery and likely never will. The sheriff's office also claims a recording of their investigators saying they wanted to hold back some evidence until a preliminary hearing was taken wholly out of context and had nothing to do with providing evidence to the defense. But the state filed a transcript of that recording. The investigator states, the discovery order came sooner than we expected, which means anything that witnesses have said is going to have to be released to the defense. We were just hoping we could at least get through a preliminary hearing before that happened. We asked KSL legal analyst Greg Skordas to review the agency's claims.
It appears that the state, either the law enforcement or the prosecution or whoever, was trying to at least stall the release of information.
It's demonstrably false.
Prue represents his in-laws, who were among many named in that 151-page victim statement.
You've got a law enforcement agency making substantial and material misrepresentations about these sorts of things, and it's extremely troubling. It's very upsetting, frankly.
We asked to interview Sheriff Smith about that statement, but a spokesperson declined our request. We also reached out to the courts for reaction to this criticism. A spokesperson told us they can't speak about specific cases, but they believe in this case the court record speaks for itself.